Supplementary list for orders item number 1.
Lord, item 1, my lord, on behalf of Mr. P.C. Mishra, 2 weeks time for removal of defect.
This is a 2021 matter, sir.
Yes, my lord.
Should have removed it by now. It's a 2021 matter. What is it about?
Matter was, my lord, was the confiscation case number 27 of 2009 and 10.
Tell us about it. What is wrong with the impugned order?
This is not my brief, my senior.
Not your brief. We'll pass it over. Whosoever brief it is, ask that person to come. All right. You tell him that these judges are bothersome. They're unnecessarily asking questions about the matter. All right.
Please give
Just tell him the 2 judges are unnecessarily bothering us by asking us what the appeal is about. Please come and explain, you tell him. All right. Pass over.
Copy them. Please give me a copy so that I will be also ready. Copy over there.
Item number 2.
8 PG Lordships, I may be permitted to withdraw and file a better application.
All right. This post is withdrawn with liberty to file a better application.
Obligation.
Better petition. Right.
Item number 3.
May I please your lordship? I have filed an IA for appropriate order for impletion of the opposite parties who are the intruders who are causing disturbances for which PIL is filed. So, your lordship may kindly have a glance. They are the intruders who are opposite party number. They may be implemented as opposite party number 5 to 10.
No,
private
you make a
opposite
representation.
Yes, madam.
When?
I have made representation before the Deputy Commissioner Police, Municipality.
Where is that? Which annexure is that?
Annexure. Annexure 3, my lord.
Annexure?
Annexure 3.
This
And
went
annexure
for
2.
the Human Rights Commission.
No, Commissioner CMC.
No. There seems to be some proceeding before the Human Rights Commission.
Yes.
What is that
Annexure
proceeding?
11. Annexure 11.
What is that? What is that proceeding?
Their proceeding is only they have accepted the grievance and no order regarding to take.
So you've
action.
already gone to the Human Rights Commission.
Yes, my lord.
For removal of encroachment, you go to the Human Rights Commission.
Human Rights Commission and Deputy Commissioner of Police and
No. For removal of encroachment, the right authority is Human Rights Commission.
encroachment, not the encroachment, my lord. They are causing disturbance. They are
So
causing
anybody causing disturbance, go to the Human Rights Commission.
and disturbing the peaceful living of the petitioners.
You better decide whom you want to go to. You want to go to Human Rights Commission, you go there. If you want to come here, you come here. You can't say, I'll go there. That queue is not moving fast. Let me try this.
Your lordship
be
may
like-
direct the opposite party number 1.
Have you heard of this expression, forum shopping, madam? Have you heard that expression?
No, my lord.
No. It's a very important expression in law, forum shopping.
Yes.
Maybe we'll adjourn it. You just go on Google also, type out forum shopping, and then say courts. All right.
Yes.
You'll get a large number of decisions, including Supreme Court decisions. So we'll do that. We'll just adjourn it. You do this exercise and come back. Then you will understand the question we're asking you. You have gone to the Human Rights Commission. There, your case is not progressing. Now you have come to this court. Now, when we adjourn it, you will go to some other forum and say, even the High Court is not taking up my matter.
No.
No. So you better find out at the request of counsel for the petitioner list on. (20) 20th April. All right. 1 month's time to find out about what is called forum shopping.
The opposite party may be implicated, my lord.
First, you find out what is forum shopping. You enlighten me on that, and then we will decide that.
Item number 4.
Pray for 1 week time to remove defect number 22.
This is a 2021 matter, sir.
My lord, PIL matter can take
I
it
know.
up next week, any date.
Not really, sir. Where is your paper book? Where is your paper book?
File.
You have it?
No, madam.
No, not necessary. High Court, when you go for a matter, not necessary to carry paper book. Correct? No need for paper book.
Paper book.
You talk to him in Odia. I think he's not understood what I'm saying. Just tell him in Odia.
पेपर बुक दरकार नहीं ना कौन
File sir पचारंतु file.
फाइल आपण पाखरे अछि ना नहीं
Let's in fact he is not.
No, my lord. I have no file today. I am not ready today.
You can come to the High Court for a matter without file.
Madam, can it taken up next week any
No,
day?
no. What happened to your file?
Sorry, madam.
No, what is sorry? Where is your file?
File has been misplaced, my lord.
Misplaced. Then that's a good reason to dismiss.
Madam, can it taken on next week?
No.
Any date, madam.
Sorry, sir. Sorry. You're so casual about High Court. So casual. Walk into the High Court, don't carry paper book, nothing. Just go in, ask for adjournment. Somehow courts will grant adjournment. Sorry.
Monday.
2 judges are not sitting for this, sir. Sorry. You have to be more serious about your cases.
My lord,
Is
Monday.
the counsel the petitioner appears without the paper book and simply asks for an adjournment, saying he's not ready. When asked whether the matter can be passed over for him to bring the paper book, he says he has misplaced the paper book. The petition is dismissed for non-prosecution with permission to the petitioner to revive the petition, to seek restoration of the petition as and when he's able to find the paper book.
Bless.
For me, it's all a learning experience, sir. I don't know. The progress of the bar, I could never dream as a lawyer. I'm sure many of you going to a High Court without paper book. Unimaginable. If my senior knew I went in a matter without paper book, I was in for trouble. We could get fired from the chamber if we did this. Yes.
Item number 5.
Lord, one last chance may be given to remove the defects.
What is the matter about? Tell us.
Lord, here the petitioner challenges the illegal action of the OP number 1 to 3, allowing the OP number 4, the private opposite party, in the participating in the tender process.
The tender is dated 8th April 2022.
All
1 year back, it
infractions.
must have been.
The tender in respect to which relief is sought was floated on 8th April 2022, almost a year ago. Clearly, the matter has become infructuous. It is disposed of as such.
Item number 6.
Item 6 kindly one pass, sir. Lordship, because
All right, pass
affidavit is coming, Lordship.
Pass. You have the paper book or you don't?
No, in Lordship.
He can conduct the case without.
No, Lordship, I am always Lordship. The paper book, Lordship. I never.
All right.
Item number 7. Not 7 is not, this is regarding grant of on license, but my representation is before the government is pending annexure 12. Not Lordship directed the similar matter to by 31st to consider.
Or the extended period.
Yes, Lordship, that is not there. In one case, Lordship's
Yes,
ordered,
yes.
but that is a different some fact, so that's why I have not brought that up. Lordship, that says also after that.
Okay, the final decision para 2.
Yes,
Not later than 31st March or by
not the extended period by the government.
or such date as may be the extended last date as may be ordered by the government and will be communicated.
Obliged. Item number 8.
May it please your lordship. Your lordship, here the petitioner challenges the inaction of opposite parties number 2, 3 and 4 by state is starting the construction of a new building, namely Jai Jagannath Godavari Sahayog Ucha Vidyalaya, in a place which is not meant to be, in spite of having
No, who's constructing it?
there comes the opposite party number 3 and 4. Yeah.
Ex-member of the Panchayat Samiti.
Yes.
All right, the petitioner's representation be examined by the collector Badrak,
Yes, Your Lordship.
and after notice to
Dated,
the petitioner and giving her a hearing
9/3/2020.
and getting inputs from opposite parties 3 and 4. The reasoned order shall be passed not later than 15th May and be communicated to the petitioner within a week thereafter. The court clarifies it is not expressed in it.
Oblige, Your Lordship.
All right.
Item number 9.
My lord, in Odisha State Commission for Women, all the posts of members, 6 members posts are lying vacant since 21st November
We'll take
2020.
instruction. My lords, the other commission matter, my lords, already 3 of them have been appointed.
This is not acts of commission, this is acts of omission. Omitting to appoint. All right.
I'll take instruction.
You say it up the council, you say the petitioner who appears in person states that the posts, all the posts of
Members,
how many posts?
6 members.
All the posts of members of the Odisha State Commission for Women, bracket OSCW, are at present vacant. Only the chairperson is there.
Only chairperson is there.
Full stop. It only has a chairperson as of today.
5,612 cases are lying, my lord.
The OSCW has 5,612 cases pending with it. Full stop. Paragraph. You say notice. Mr. Mohanty accepts notice on behalf of the opposite parties 1 and 2. So there is a secretary.
Convener secretary.
One secretary. Convener secretary.
Convener secretary is the one secretary to the commission.
That post is filled up or even that is vacant?
That is most probably not vacant because an official is of the
supposed to be there.
That is occupied by a government office.
Oh, I see.
Government nominee.
All right,
Secretary
all
is
right.
government
So
office.
who will accept notice for that?
Actually,
Child and Welfare Department.
Women and Child Welfare Department.
WCD Department.
He accepts for all 3. All right. An affidavit will be filed by the secretary,
Women and
Child Development Department, Principal Secretary, Women and Child Development Department, on or before 1st May 2024, 23. 2023. That correctly it's typed. I don't want you to think it's 2024.
My lord, earlier, my lord, I may pray for an earlier date so that it will.
One month, sir. You have to give them 1
Within
month.
that period, we may.
If the state government acts faster than that, there will be a miracle. 1st May 2023, by which time the court expects that steps would have already been initiated for filling up the 6 vacant posts of members. Full stop. The fact that there are over 5,000 cases pending with the OSCW should itself be sufficient reason for urgency to be shown in the matter. List on 8th May.
8th May. Obliged.
Item number 10.
May I please, Your Lordship? So, premises of the Jitanagar Government UP School has been encroached by the BDO and this Kedarpur Gram Panchayat for construction of the facilitation center and Gram Panchayat gate. I have made representation which are at annexure 5 and 6. No action has been taken, Your Lordship. Annexure 2, which I have sought information from the DEO, shows that they have encroached the land of the school, Your Lordship.
Video is encroaching.
Now, where is the acknowledgement of this representation?
I have handed it over. Your Lordship.
Can't be. Can't just hand over.
Your Lordship may grant me 1 week time. I'll try to obtain the acknowledgement.
No,
to that
you
effect.
file a fresh one. This time obtain a proper acknowledgement. You say,
Your Lordship may grant me one opportunity so that I can ascertain whether there is an acknowledgement to that effect or not.
all right, at the request of counsel for the petitioner, who wants time to produce the proof of receipt of representation? by the opposite parties. List on. March 22nd.
The factum of the encroachment is within the knowledge of the government, Your Lordship.
All right.
Item 11.
Much of it.
Item 11, my lord. Conducting counsel, Miss Bobita Sahu is not well, my lord. May I pray any day next week? He has conducted the case from writ applications he has conducted, as well as he is also looking after this writ appeal, my lord. Even if Monday, your lordship can be taken up.
127 days delay.
Yes, there is a delay and notice was issued.
What happened after notice was issued?
My lord, senior is appearing, my lord.
Who? Yes, Mr. Monty.
It is not hard, my lord. That is all pending. Not hard. Yet.
No, can you come to the mic? No, you'll have to go to the mic, sir.
It is only on the stage of admission. The stage of admission.
No. All right. He's requesting for adjournment. Are you opposing it?
She's ill. I'm
all right. Counsel for the appellant is stated to be unwell. Mr. Monty does not oppose the request. Monty, counsel for the respondent does not oppose the request for adjournment. List on 31st August.
Item number 12.
My lord, August. My lord, August.
All right, sir. See, this has been pending since 2019. We want her to get fully well. At her request, some 5 adjournments have been granted already.
No, Lord,
let her be fully well, then you'll also have a good chance not to agree to a request.
She only asked for the accommodation for Monday, till Monday.
No, but we don't know. She will again fall ill, sir. We don't know.
I'm sorry.
No problem. If you look at the history of this matter, only adjournments. No order has been passed so far in the matter.
She has
so 3 adjournments, 1 dismissal for default, 1 restoration, 2 adjournments. Today is the 3rd after restoration, 3rd adjournment.
Only question is
the history of this writ appeal is adjournment.
Implementation of this order.
So all that, how serious you are, we'll know. Next hearing, you will then be fully geared up saying, sir, no, this is too much. How many adjournments are you going to grant? You have to say that.
There is nothing in the
You're not
appeal.
saying that.
There is nothing in the appeal. Monday.
Right,
He's asking for Monday.
No, it's all right. Yes.
Item number 12.
Well, there are 2 appeals.
Yes.
2 appeals before the lodge.
Yes.
One against the final judgment, one against the order filing an application for review.
Yes.
My lord, here what has happened, if your lordship may kindly turn to my grounds at page 15
yes.
of the brief.
Yes.
My lord, the present appellants before your lordship were not made parties before the honorable single judge.
Right.
Even certain persons had died during the pendency of the case. They were not substituted, no partner, and order was passed. I filed an application for these parties that you recall the order and rehear on merit after giving me opportunity. That was also turned down. In the review order, your lordship will see the honorable single judge says, your lordship will see, consider at the next writ appeal at 112 at page 12. Considering the submission of the learned counsel for the petitioner, the court finds that judgment having been passed with the materials available therein for the disclosure made during the course of hearing, judgment involving OGC.
So who's for the other side?
No, notice has not gone. There is a limitation. Because as we had no knowledge about the judgment, because we were not at all made parties in the before the honorable single judge.
All right. What has happened as a result of the impugned order?
Well, he has set aside the order of the revision.
No, you've only given the order in the review. What about the main order?
Well, the main order here, lordship will see, I have annexed in WA number 110. In the main order, the honorable single judge has set aside the orders. Your lordship will see paragraph 8. Now coming to the considered the validity of the revisional order, the court found the reason assigned therein above the consultation authorities is bound by the order of the revenue authority and for the Jamabandi tenants ledger indicating the name of the petitioner's father as a tenant during vesting of the
No,
intermediate.
what is the consequence of this? Some
Well, the
ROR has been changed.
No, now till that ROR has not been, the revisional order has been
All
set
right,
at
notice on everything returnable.
in both
Notice on the
the
applications for delay as well as in writ appeals, both matters.
obliged.
Returnable on 5th May. Not 5th May, sorry.
My lord, I take notice to only OP number 1 because others are pro forma. They are of our family members. Only OP number 1.
Or
Respondent number.
returnable on 3rd May. Notice to, you say at the outset, counsel for the appellant states that only only respondent number 1 is a contesting party. How can you say that, sir? Just
Because he was the writ petitioner. He was the writ petitioner before.
Achha, only respondent number 1 is the contesting party, as he was the writ petitioner. Notice to respondent number 1 returnable 3rd May. All right, in both matters on appeal and applications. Right.
Lordship, may pass over matter.
Item 6. Wait, sir. This
Item number 13.
Page 62 is the order. The first day disposal, what has happened, my lord, in this case? RSCP was closed with effect from 31/12/2015. On introduction of MSCP, your lordship, I have given that notification, your lordship can turn to page 25. That the rule of 2017 ORSP rules. As for rule 13, your lordship may say, I have at page, your lordship may say page 35. Modified assured scheme shall come into effect from 3rd day of January 2016 with implementation of the rule to address stagnation of a government employee. The scheme so and so. Then your lordship may turn to page 39. The revised assured progression scheme shall cease to operate with effect from 1/1/2016. The operation employee so and so, my lord. What has happened in this case? He is claiming 3rd RSCP. And his 3rd RSCP is what he is claiming, that is falling on, my lord, 27/10/2016. As for the MSCP, he has been granted 3rd MSCP, he has been granted. So this is
you are appearing for the respondent.
You are appearing for the respondent, your lordship.
This is a first day disposal.
There is a direction to consider the representation, your lordship.
Not representation to consider in accordance with the judgment relates to
by this honorable court in a Biharlal Bari case, your lordship.
But that relates to RSCP who have retired prior.
No, but where is the counter affidavit in this?
No counter affidavit. Page 62.
So when the judge says pleadings, what is pleadings?
Your lordship, looking at page 62, my lord.
No, taking this court to the pleadings, meaning what? Only the writ petition?
Yes.
Oh, no counter.
No.
This is first day disposal, let it go back.
To consider the representation.
First, consider the writ petition, let him file a reply to the writ petition.
He will file a reply if, yes, ma'am.
Your lordship is reminding back
to the single judge.
Obliged, your lordship.
The impugned order dated 10 September 2020 was passed on the very first day of hearing, issuing directions to the present appellant regarding consideration of the case of the respondent in light of a judgment of a division bench of this court, which according to the appellant is not applicable
yes,
to the case of the respondent. Paragraph. Although the impugned order mentions that counsel for the respondent had taken the court open quotation to the pleadings and the claim involved herein, unquote. What was meant was only the petition and its annexures, because there was no opportunity to the present appellant, bracket, opposite parties in the writ petition, bracket, to file any reply to the petition. Paragraph. On the above short ground, the impugned order is set aside and writ petition civil 21558 of 2020 is remanded to the file of the single judge in the roster bench, where it will be listed on 3rd July 2023. The present appellant will file its reply to the petition on or before 21st June 2023. And the respondent, that is the writ petitioner, will file the rejoinder thereto, if any, on or before 3rd July 2023. Full stop. It is made clear that there will be no further adjournments granted for this purpose. For the said purpose. Full stop. The learned single judge is requested to then proceed with the petition on merits and dispose it of as expeditiously as possible.
Public.
Item number 14.
As item 14 relates to my lord's rehabilitation assistance scheme. My lord's is posting it to 30th of August 2020.
All right, same order.
Item number 15.
Item 15, my lord. Promotion during pendency of departmental proceeding. And the lordship is urgent to 27th March. I am giving the next date is fixed to 27th.
All right, same order.
Item 16.
Item 16 is also my lord's rehabilitation assistance. 30th of August.
In the meantime, let them serve me a copy of the opinion.
Yes.
Grateful.
Item 17.
My lord, may I permitted 1 week's time to remove the defect?
All right, list on.
Item 17.
Yeah, 22nd March. Defects we removed in the meanwhile.
Obliged.
Item number 18. Eighteen.
18 is the departmental question. Similar to item 15. Man.
Item 19.
19 you'll also may fix it to 23rd. This is the contractual matter.
All right, 23rd.
Item 20.
Wait, please, ma'am. Item 20, my lords, your lordship have posted this matter to 29-3, my lords. 29 outsourcing.
We were not even noticed. And the university, I was not even noticed.
Let it go back, sir.
Man, let it go back.
Well, there's certain matters, those who have not been, it's covered by Rasmi Rekha Das judgment, my lord. Your lordship
have not even been noticed.
I have not even been noticed. Suddenly I receive an order that agreed by councils.
The impugned order was passed on the very first date of hearing without notice to the present appellant, who is the main contesting party. On that short ground, the impugned order is hereby set aside. Writ petition civil 35875/2021 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 3rd July.
Well, I have only
the
one.
present appellant, who is the opposite party in the writ petition, will file its para-wise reply to the petition on or before 21st June. And the present respondent, who is the writ petitioner, will file a rejoinder that on or before 3rd July. No further adjournment will be granted to either party for this purpose.
Grateful.
Well, I have only one
The single judge is then requested to proceed with the matter on merits and dispose it off as expeditiously as possible.
Grateful.
Well, I have only one prayer, my lords. Well, the respondent in this case, my lords, is not being allowed to continue. Let them allowed to continue till then.
Okay, whatever is today's status quo will continue. That's it.
That status as on today, I'm out of service.
Anyway, if you're out, we have said expeditious disposal. Let's see.
Despite there being a direction to regularize me.
That's right, because that was passed ex parte, literally ex parte. Yes.
Grateful.
Item 21.
That's item 21. Well, this pertains to absorption of DLRs into work charge establishments. And the single judge has said that it should relate back to the day from when they were DLRs. Similar matters, have posted to 14th of September. I'm passing.
Same order, 14th September.
Right. Item 21 is urgent copy.
Yeah, urgent copy. All right.
Grateful.
Item 22.
Item 22 is also the same on work charge establishment.
All right, same.
Item 23.
23 millards is also same. 24, 25, 26. Till 26 millards.
All same. All right.
Item 27.
That's item 27. As regularization of DLRs, my lords have posted it to 24th of April.
All right. Same order.
Item number 28.
Yes, item 28 and 29 are also Millard's regularization of DLRs 24th of April 2020.
All right, same order.
Item 30.
Item 30 to 32 and 33 to 34 to 36.
30. Item 30, sir. 30.
Yeah, 3 through 32.
My lord. 34 to 36 and 34 to 36 permitted to
34 to
36. Permitted to withdraw.
Withdraw. All right. All right.
Activity would
dismiss this withdraw.
Item number 33.
Yes, 33, my lords, is regularization of DLRs, my lords.
24th April.
24th of April.
All right.
Item number 37.
37,
Same.
my lords, is also same, my lords. Regularization.
May I beg pardon, my lord? The copy, read appeal copy has not been served.
They'll serve it.
They'll serve.
And my lord, I beg your lord's pardon. Another 8 matters not before lordship board today.
So
may come along with.
Was all this first day
Yes,
disposal?
my lords. First.
I'm giving the list, my lord.
Sir, they're very happy you've appeared. So now can we send it back with all first day disposal?
My lord, yes, limited back. So all 8 matters, my lord.
All 8 matters. Are you appearing in those 24th April matters also?
Your lordship fixed it on
24th April.
8th May.
Yes,
And
all
honor
are
before.
first day disposal.
If you're agreeable, we can take it all on board and reduce the burden on 8th May.
Yes.
If you're agreeable.
No, not 8, May, 24.
All 8 matters.
All right. All these matters, you say these were the impugned orders were all passed on the first day without any opportunity to the appellant to file a reply to the writ petition. On that short ground, the impugned orders are set aside. All these writ petitions are restored to file of the learned single judge in the roster bench, where they will be listed for hearing on 10th July. The reply to the writ petition, Paravis reply, will be filed by 26th June, rejoinder by 10 July. No adjournment to either party. Further adjournment for this purpose. The learned single judge is requested to proceed in matter on rights and dispose it of as expeditious.
Not copy, read appeal copy, they will serve to.
Sir, all the DLR matters today,
Yes.
can we say you are applying?
He is appearing.
Today's DLR matters.
Today's DLR. All are first
Put
day.
all the DLR matters together, put his appearance, and all DLR matters will go.
No, so not in all, my lord. I'm in this appeal, I'm appearing. Another 8 matters which are placed before lordship's board. That
Only that,
yes,
not the earlier ones.
No, not others.
Sir. All right. All right.
37 and all this.
Together.
30.
This will be a special notice, whatever. Taken on board, TOB or whatever.
Item 38.
Yes, 38 is Millard's rehabilitation assistance scheme, 30th of August.
All right.
In filing the appeal, there is a delay of 318 days and copy.
Only notice on all that, sir.
Yes, madam. Copy may be submitted.
So he accepts notice. Notice, he accepts notice. 30th August, stay of the. No, whatever is the order. Right.
Item 39.
39 regarding the pension of work charge employees, your lordship has already issued notice. And the next date I have given written my.
Item 40.
40 is said.
Item number 41.
41, my lord, promotion during pendency of the departmental proceeding that are similar to item 15.
Item 15, is it?
15, my lord.
1-5. Same order, same date.
Item 42.
42 also is a departmental proceeding.
Same.
Item 43.
That is also departmental proceeding.
All right.
Item 44.
44, my rehabilitation assistant. Your lordship.
30th August.
Well.
Item 45.
Your lordship, you kindly give me, my lord, 2 weeks time to remove the defect, my lord.
All right. List on 3rd April. Defect procured in the meanwhile.
Item number 46. Item number 46.
None appears dismissed on opposition.
Item 47.
47 Sarta Prada.
8 May.
8 May.
8 May tallies 406. We had this now.
Item number 48.
So how many? Sarita Parida, how many?
More than 1,000.
1,000.
More than.
We'll have to have dedicated Saptaparita days.
On that day, only one case your lordship may list and Mr. Khuntia will be there. We will go on that day.
That order will be 5 minutes. All right.
I'm
pitying my stenos. Anyway, all right.
I'm 48. I am appearing for the respondent.
Item 48.
48.
Yes, sir. What is it? 48.
This is your lordship may page 221 annexure 4 in the impugned order. The direction has been given treating the subjects which are not prescribed in the advertisement as equivalent. Your lordship can find it from page 238.
No. So what has happened here? Because this is a 1-year-old judgment. 6th May 2022.
That is not. Earlier it was before my lord.
Directs to consider the candidature in the light of the fact.
Their candidature was rejected.
No. And you've been asked to reconsider. What happened?
That your lordship has taken up this matter on 18/11/2022. So
Contractual trained graduate teachers and Telugu teachers.
What has happened? May I drop my lord?
No. Is there a contempt petition? That's what I want to know.
No.
Did you implement the order? No.
No.
But you were to file an affidavit explaining the overall rationale.
Yes, my lord. I have to file in the Bintech. I have filed an affidavit, but that is not in my file. That part D is the affidavit. Your lordship, may I pay your lordship? May call this matter on Monday?
No. Do you have the copy of this additional affidavit?
Yes, lordship.
But in my file, that additional affidavit is not
Filed on 5 December 2022.
Correct.
May I pray your lordship?
In an identical case, Supreme Court has set aside.
Yes.
Indresh Kumar Mishra. What do you have to say, sir, to Indresh Kumar Mishra? What's his name? What do you have to say to Indresh Kumar Mishra? Judgment of the Supreme Court.
Your lordship.
Annexure A to this affidavit.
Yes.
Annexure A to this additional affidavit is Indresh Kumar Mishra.
I have gone through the decision. This decision is not at all applicable to me. Fact remains, this judgment is totally based upon the postgraduate qualification. But here is the advertisement. So far, this present writ application is concerned, that is in graduation. Graduation in economics. My lord, economics as a school subject. So in the commerce stream, the economics is known as macro and micro. That has not been duly accepted, for which this honorable single judge has passed the order in favor of me, which has been assailed by
No, but if you have to have BA in economics, you have BCom, you have, is it?
I have become.
But that's not as same as BA in economics,
yes.
sir.
What
they required was BA in economics.
No, my lord.
Yes.
Let's see
the advertisement.
Can have a glance to the advertisement.
Page 55.
Page 55.
I am reading. My bachelor degree in arts, commerce, or Shastri so. Then, my lord, your lordship may provided that in any case, the candidate must have passed bachelor degree with 2 school subjects offered as pass, honors, elective, optional, compulsory subject out of the following: English, Odia, Hindi, Sanskrit, history, geography, economics, political science. So he has not that subject of economics. That is the school subject.
No. He says she has microeconomics or
But yes.
In economics, macro and micro is there, my lord. It is the integral part of the economics. They
Correct.
cannot show it. They segregate.
So where is your school certificate?
Exactly, my lord. That is also very much available in my +2 and +3.
No, where is it? Where is your certificate?
Certificate, my lord. So far the writ application is concerned, it is, I'm saying it from the writ appeal, my lord. In writ it is 48, my lord. 48 and 49. So for the mark sheet and certificate is concerned. In writ appeal, it is at page 85. 84 and 85. This is a Bachelor of Commerce given by the Sambalpur University in subject of examination, compulsory subject, communicative English, business economics. Clearly it has been written as in my certificate.
Business economics.
Yes, ma'am.
This is in the bachelor's degree itself.
Bachelor degree
school,
itself.
In school, what is school?
School subject, we have specified it as only economics, my lord.
No. Where is your school subject?
My lord, kind of a glance to the advertisement which my learned friend is relying upon, page 55 for a moment.
No. What you showed at page 84.
Yes, ma'am.
This is your diploma of Bachelor of Commerce.
Exactly.
No, we are on BA with school. In the school, what did you have?
My lord, school, in fact, in HSC, there is no such subject in economics.
No, there is. In the +2 stream, there is economics, sir.
No, yes. That is in +2. Our 10 +2 +3.
Correct.
In HSC pattern.
Correct.
So in +2, I have got the economics as a subject.
Where is that? Show us.
No, perhaps that is not. That is page 85.
No, all that is your bachelor degree.
My lord, the minimum educational qualification and professional qualification as it is specified in the advertisement, the qualification is bachelor degree in arts or commerce.
Don't stop there. Read continuously.
Or Shastri in Sanskrit, degree from a recognized university having school subject, 2 school subjects. School subjects as defined in the proviso under here from a recognized university having 50% of marks. So then I am coming to the next.
2 school subjects.
Exactly.
Means that in the +2, in your school,
yes,
you should have had one of these subjects, 2 of these subjects.
Yes, ma'am. Then coming to the next. In case of the candidate must have passed the bachelor degree with any 2 school subjects offered as pass, honors, elective, optional, compulsory subject out of the following. One is English,
So
Odia, Hindi, Sanskrit.
School subjects.
Exactly.
In the school, you should have had these subjects. So what is your school degree? School certificate. In your writ petition, you must have annexed your school certificate.
Yes, ma'am.
Where is that?
Can it be passed over, manner?
No, 1 minute. Page 46, that is for B.Ed.
B.Ed qualification.
48 is all this is autonomous college. Banki Autonomous College. Bachelor of Commerce. Your school is not there, sir. I think the point is being missed about school subjects. If you have done it in your school, that's what it means, not in the college.
The person who is having ICOM, then in the bachelor degree, it will be BCom in commerce.
Correct. All that is that bachelor's degree together with, that's what the advertisement says, together with 2 school subjects. What is your understanding of school subjects?
School subject, that means that is up to +2 is school. At least one must have economics in +2.
In the school, in the +2.
At least because in HSC there is no economics, so far as ODI schools are concerned.
I see.
So in +2 there is a subject of economics.
Right. For both candidates, the same problem.
Both candidates same problem.
So can you produce your school certificate?
Yes, ma'am.
All right. Mr. Manthi, learned counsel appearing for the respondents, seeks some time to produce the school certificates with mark sheets of both candidates. That is request list on 4th April.
Depublish.
Item 49.
My lord, 49, my lord, kindly taken up 2 weeks time to remove the defect, my lord. And my lord, the same case, my lord, W1237 is the same case, my lord. Kindly taken up in W1237, 2022. Same.
It's not listed today.
Non-listed today.
You say list on 11th April along with that WA, what is that number he gave?
1237.
All right.
2022.
22.
Defects be removed in the meanwhile. Right.
Item number 50.
Wait, please, Lords. Here also similarly, my lords, we had filed for the my lords college. I had filed the wakalat. My name was not reflected, my lords. Our name was not there. So just few minutes before the matter reached, my lords, somebody informed. So our associate went to ask for time, my lord. The matter was disposed of. Lordship, page 7.
First day.
Disposed of. And my lords, it could not be brought to the notice of the Honorable Court that the petitioners are not even qualified, did not have
what is happening was with the impugned order, not implemented.
My lords, I'm sorry, I couldn't.
No. Was the impugned order implemented?
No. Not yet been.
All right. Notice returnable. 15th May. There should be a stay of the impugned order till that.
Great. Both are same. 51 is also same.
All right.
Item 52.
Great.
52 is similar to item 48. Both the matters.
Same as 48.
All right. Item 53.
53, my lord, old pension scheme.
Lord, I have already entered appearance for only sole respondent. I pray let them to serve the copy so that I can, limitation is there also.
Sir, all these are first day disposals, I think.
No. It is not the first day, Lord. It was filed before the learned tribunal and that was transferred. Here matter was disposed of after hearing the parties. Your Lordship may kindly see paragraph 5 and 6.
Transferred, my lord.
And so it is also covered by my lord's decision dated 15/2/2023, my lord.
All right. You say notice, he accepts notice. Or is it already after notice? No.
No, my lord. First time.
All right.
They have.
And your lordship has already issued notice in a similar case.
I'm giving list along with.
My lord, that is 687 of 2022.
All right. List along with 687. Which is the date?
That next date 13/4/2023.
All right. 13/4/23. There should be a stay of the impugned order till then. All right.
Item 54.
54 same, my lord.
All right.
55.
But he doesn't appear. You don't appear in the other matters.
No, my lord. Others, he has not appeared.
All right. You simply say notice, then same order in this 54, 55.
55 and 56.
56.
Item number 57.
57, my lord. This is, your lordship has fixed it to similar matters, your lordship has fixed to 24th April, DLR regularization.
You are there?
20.
No. 57, then you say same 24th April, same order.
Item 58.
51 was urgent copy.
Yeah, sure.
Item 58.
58, my lord, short of
8 May.
8th May.
Item 59.
May I please, yours? The petition was a non-pensionary category employee, my lords, who expired in 1991. And in 2009, my lords, the opposite partner 2 issued an official order that the non-pensionary category to pensionary category. And in the matter, there is an option for my lords. That is annexure 1, my lords. That is annexure 1, my lord, and glass to page 12, my lords. That is the employee who has exercised his option and willing to come over to OPTSL pension scheme, page 12, my lords, shall deposit the employee share of provident fund and differential industrial gratuity amount already received with 9% interest up to date in shape of account paid bank draft drawn in favor of nationalized bank in favor of the director so and so submit an affidavit certificate.
No, but you have not challenged the main order.
Yes, just 1 minute, perhaps. In this formula, there is an option form and an order taking. I have submitted the option form and order taking. And opposite party, my lords, that they have filed a counter, they have also admitted that we have received the option form.
No, 1 minute. In one writ appeal, you are challenging 2 orders.
No, one writ appeal, my lords, that is one. I have filed a review of.
No, but in one writ appeal, you are challenging both the main order and the review order.
Yes, my lords.
I don't know what the practice here in this court is.
Then on the same matter, then I filed a review application where document was available and that was not taken into account, and that also dismissed, my lords. Opposite party admits that we have received the document, and my lords, that is the Honorable Judge, my lords, single judge, my lords, that is page 26, my lords. Page 26, they have pointed out, page 26, 6th line from the top, my lords. Perusal of the pleadings as well as the consideration of the submission of Mr. Panda, Learned Counsel to the petitioner. This court nowhere finds that any statement coming forth regarding either deposit of the required amount or filing of an affidavit for retention of such amount from the pensionary benefit, in absence of which the court finds that application submitted by the petitioner was not in terms of clause 4.
Just say notice returnable. All right. Notice returnable. 16th May.
Yes.
Item 60. Item number 60.
The 62, my lords, 64 are all old pension scheme matters. My lords, they posted it to 13th of April 2020.
All right. 13th April, 60 to 64.
Item 65.
65 is a rehabilitation assistance scheme. My lords,
30th August. All right.
Item 66.
66, my lord, short of 8th May.
Item 67.
67, my lord. Similar matters have been posted to 8th August 2023 in WA number 1403 by 2022.
Here, my lord, there's a slight difference. That's here the home guards. This is also against the reservation of home guards that matter. But here, if my lords will turn to page 48, which is the counter that has been filed before the tribunal. So they had to qualify in the written test as well.
So written she failed by.
And my lords, para 4, they have only scored 5.25 marks. And the pass mark for SCBC was 14 and SC/ST was 12. So they assert that there should be a cutoff for home guards, but it's a.
What is wrong with the impugned order? You have not implemented the selected parties.
The same issue has been posted by your lordship in
Because
batch of
that
cases.
case they had
In
implemented.
relation to reservation of home guards.
No, but you have to implement the correct selected candidates.
Since there are so many number of posts are lying vacant till 8.
So you still have to.
As per that recruitment here.
You've got 5.25 marks, sir.
They have not specified the last cut-off date, cut-off mark for home guard, my lord.
What do you mean? If it's below the pass mark, how can it be? What is cut off in that?
My lord, kindly see there in counter, they have in annex, my lord, only one document, my lord. I'm showing, my lord. In the counter, they have
52, page 50.
Yeah, page 52, my lord. In respect of UR and SCBC candidates, they have fixed 14 marks for pass mark for 14. Those who have secured 14 mark, they will be passed one. And in respect of SC, ST, 12. But in respect of home guards, they have not mentioned about the cut-off mark for pass mark.
But doesn't mean that when you get 5 marks, you will get pass, sir. Even the others have to get 12 marks. 12 marks. You have got 5 marks.
And in respect of
how can it be less than even unreserved and SCBC and
I have challenged only that ground, my lord. They have not fixed cut-off mark for home guard, my lord.
Sir, please. If they fixed a higher cut-off mark, you can understand. You have got even less than what their cut-off mark is. Where's the question? If you are qualified.
In that recruitment, so many posts for home guard are lying vacant till 8, my lord.
You must have some minimum qualifying marks, sir. Just because posts are vacant, anybody can't get in. You see, the only ground on which the impugned order of the single judge dated 14 September 2022 in writ petition civil OAC number 2284 of 2015 is challenged by the present appellant is that she was in the single quotes home guard unquote category for which there was no minimum qualifying mark prescribed. Paragraph, it is seen from the advertisement that there were minimum qualifying marks for all other categories. That is UR/SCBC, UR, SCBC, SC and ST. And the minimum qualifying mark was 12 in the case of SC and ST. From the counter affidavit filed by the opposite respondent state in the aforementioned case, it is seen that as far as the present appellant is concerned, although they passed in the physical examination, she failed in the written exam, securing just 5.25 marks, which is far below the qualifying marks out of 5.25 out of 35 marks, which is far below the minimum qualifying mark, which was 14 for UR/SCBC and 12 for SC/ST. So, no, the appellant cannot, having secured just 5.25 marks, be expected to be declared qualified only because there was no specific indication in the advertisement of a minimum qualifying mark for the home guards category. Paragraph, the court finds no merit in the present writ appeal. It's accordingly dismissed.
They have not fixed a minimum mark in the advertisement. They have fixed in the answer sheet manner.
All right.
They have not fixed in advertisement.
All right.
Item 68.
68 work charge pension similar to item 39.
12th April.
Similar to item 39, you will also pick to 12/9.
12th April.
9 September. I have given that copy.
14 September.
14 September.
14 September. All right.
Item 69.
69 will stop the product.
Item 70.
Item 70, there are 2 appeals.
Yes.
Before I take a lordship, merits involved here, the delay of 35 days are there. Council of Higher Secondary Education is the appellant. Question of Malayalam city's applicability is the issue, madam. And your lordship has been passed to, have been pleased to pass orders referring to Seo Sankar's case. But applicability of the amended rules is qua the application filed by the person. If your lordship sees this person, date took place in the year 2015. prior to the new rule coming in.
So again, first day hearing.
Beg pardon?
Order passed on the
The first day of hearing, my lord, without giving us a notice.
See, no delay is condoned, notice returnable. The similar matters coming up? No.
But I have no idea.
15th May.
15th.
Stay till in the meantime.
The second matter delay is 100 days, my lord.
Rehabilitation
delay control
is coming 30th August.
13th August.
Rehabilitation is coming 30th August.
30 August.
Let it come in May, my lord, that will be decided.
Yeah.
It's small issue of without filing counter.
Right.
Item 71.
The opposite party have already complied my grievances.
All right. Counsel, the petitioner states that the grievances have already been addressed. The petitioner is disposed of as having come instructions.
Item number 72.
May I please, Lord?
72, please pass over.
My lord, I'm filing the affidavit today in court. Personally, the order I am filing is the Puri temple case, my lord. So, for conservation of Natamandap in this concern, I have already get a permission from the temple administration, and the work has already been started on 14/3. It will continue till 13. Your lordship may kindly glance at page 7.
All right. Say the Archaeological Survey of India has today tendered an affidavit stating inter alia that it has obtained permission from the Sri Jagannath Temple Administration Puri for conservation works of the Nata Mandapa and has been permitted to undertake such work between 14th March to 31st May 2023. It is further stated that the ASI has already constituted a revised technical expert core conservation committee for the Sri Jagannath Temple under the chairmanship of the Additional Director General Conservation ASI. Full stop.
They are going in self treatment. Last time we have ordered, they have after 3 months they have committed.
Anyway, some beginning has made now. Let us see.
Late than never.
List on.
Same also Konark. Because they have for Konark also, they have done it.
They have started the work in Konark.
Yes.
List on now after Ratha Yatra.
Yes, sir.
List on 10th July. 10th July.
Yes, sir. Melody,
WPC number 9792. 9792 18/10/2022, my lord, has directed the temple administration to file affidavit about the Ratnabandar counting the belongings of the Lord, my lord. But they have till yet not filed the affidavit. In 9792.
Who's the Jagannath temple? For the temple, there's somebody usually appearing.
Mr. Satpathy is there, but he's talking another court.
In 18/10/2022, my lord, directed
despite the order dated 18/10/2022 till date, no affidavit has been filed by the Sri Jagannath Temple Administration in reply to the present petition. The reply will be positively filed on or before 26th June 2023 and rejoined that too before the next date. This is the second matter. List on the same. All right.
That is also 10th July, same.
Item number 73.
Berhampur Municipal Corporation is filed now.
I have filed the affidavit last date, but I will be filing a detailed affidavit because the straw mortar drainage management, I have received the documents yesterday only. So your lordship may give me 10 days time to file the affidavit.
Counsel for the Berhampur Municipal Corporation seeks and is granted a final opportunity.
We have already filed an affidavit. This is further affidavit.
The further affidavit.
That was the direction to file further.
On or before 26 June 2023. List on 28th June 2023. 28th June.
My lord, oblige.
Okay. 1 minute, sir. Not 28th June. What about 3rd July also? Something skipped, right? July, sir. 4th July.
My lord.
Okay.
4th July.
Item note 74.
In this case, on behalf of
Yes.
opposite party number 6, I have filed a counter. I have served a copy on Mr. Mishra also.
Your Lordship, kindly see the order dated 2/12/19 and 8/9/2022. And thereafter, nobody has filed counter excepting OP number 6 and 8. So if your Lordship will close the case against the order of the opposite party and not accept the counter, even if it is filed thereafter, I will take instruction on the counter filed by 2 opposite parties only. And if necessary, I will file a rejoinder. Because none of the opposite parties.
OP number 8.
I am for OP number 6 here.
6.
I appear for OP
I
number.
have filed an IA for acceptance of the counter.
Yes, they have served the copy to me on February 22.
Yes.
All right. OP number 6 filed an
Central
affidavit.
government, even though they took time and again to file the counter, they have not yet filed the counter. The Union of India.
Only OP numbers 6 and 8 have filed counter affidavit so far. If the Union of India does not file its affidavit by 26 June.
And other opposite parties have also not filed by law. So that has to be taken
If
into
the
as per
other
the law.
opposite parties do not file their respective replies by 26 June, then it will be taken that they do not have anything to say in the matter. Rejoinder to the counter affidavits be filed for the next date. List on.
After 16 or after 17 or 18 July, ma'am, if possible, because I will be absent for around 3 months.
Going out.
19 July, sir?
My lord.
Yes.
19 July.
Oblige.
Item note 75. Item 75.
The 75.
Petitioner, my lord, was to file a rejoinder to the counter that the state has filed.
Where's Mr. Devdas normally appears online? All right, rejoinder be filed before last opportunity to file rejoinder before the next date. 6th July. 6th July.
Item note 76.
None appears dismissed in all resolution.
Item 77.
You are in 77, sir?
But item 77 is a appeal against this order passed under review by the Honorable Single Judge. This litigation has a checkered career. But here, after remanded orders and other orders passed, finally, an order was passed under 36A of the OLR Act declaring my bhagchesi right under the landlord. The landlord appealed. Appeal got dismissed. Appeal was dismissed on merit. Revision was dismissed on merit. Writ was dismissed on merit. Then writ he filed a review. Writ he filed an AHO, means writ appeal, which we withdrew, saying that he'll file a review. Review was filed. Review had been allowed. I came up to this on rule. Lord, before I address your Lordship, Lord, one thing I bring to your Lordship's notice. This writ appeal challenging the order of review was heard on merits, threadbare heard. But what happened, Lord, by the time the judgment was passed, the sole appellant had died. But there was a petition for substitution. The LRs were already on record, means they have appeared, and a threadbare judgment was passed, discussing all the aspects, allowing the writ appeal, saying that in my favor, in favor of the bhagchesi tenant. He went up to the Supreme Court, and the Honorable Supreme Court said
that since the person was dead, you approach the High Court. The High Court, after this Honorable Court, after in the review, said that since it is admittedly against a dead person, set aside the judgment and it has come for re-hearing. Your Lordship has allowed the substitution also, saying that it was there, by mistake it was not taken up, but the parties were there. But my humble submission is...
So it only has to go back to the single judge to hear again?
No. This single judge to hear again, not the review.
Not review. The writ petition itself, sir.
Writ petition was dismissed.
No, but that has been recalled by the review order.
No. Review.
Review is allowed.
Yes, review is allowed.
The effect of allowing the review means what? The writ petition has to be heard again or petition dismissed?
He has allowed the review petition and said that it will go back again to the Tahsildar.
Tahsildar. So it's a remand.
Yes.
Remand.
That is the position, my lord.
So how does this remand hurt you?
Remand is in this way, my lord.
To have it time bound, sir, then it won't hurt you.
That is true. But my lord, one thing is sure, that the findings which have been given
this is for last 11, 12 years.
That is what I'm saying.
First day you could have said that you wanted a time bound.
But that is what I want to bring it to your lordship's notice, that after so many years, the tenant will go back again, and again they will face a trial.
The tenant will continue to remain in possession. You're in possession.
Yes, possession.
What is your problem, sir? As a strategy, you should have grabbed this opportunity.
No. The question is, review has been allowed. Your lordship is right. Had it been allowed, and again
since you're going to remain in possession, even today we'll say status quo will be maintained till the Tahsildar decides.
Yes.
When you go and appeal against Tahsildar, against status quo will be maintained. We've all been in the bar, sir. These are golden opportunities.
Golden opportunities so far for promotion.
We wasted 11 years here.
That is what troubles me.
I have no objection. Let it be remanded. Follow the rules.
Time bound. No adjournment. Neither of you will be asked, given any adjournment.
Time. Your lordship may fix a time. Both parties will appear.
That's what.
There will be finding. What I said, there is a finding by the Honorable Division Bench of this court, where they gave the judgment, that they saw the records and found that this person's name.
That's gone, sir. We can't look into that division bench now.
I understand, but I bring it to your lordship's notice that duly constituted and technical, how far it is technical, your lordship can understand. Everyone was there. It was heard. On merits, everything, records were perused and judgment was passed. But only this technical difficulty person was.
So the question is, do you want to go to Gangotri or Gaumukh?
I leave it to your lordship. But again, that exercise of appeal revision will.
Correct. By the time you come to Kanpur again, 10 years will happen.
Then again, whether this person will be alive or not, that is also. One person who was fighting the litigation is already dead.
Right.
Now.
All right. You say the challenge in the present writ appeal is to an order dated 16th September 2011, passed by the single judge, allowing review petition 25 2009. Filed by the respondents, whereby the earlier order dated 7th February 2007, passed by the single judge, dismissing OJC number 6709 of 1994 was recalled. However, while recalling that order,
page 31 Miller, paragraph 7. That is the order.
Yes.
Ultimate direction. Page 31.
Para 7.
Para 27.
Para 27.
While allowing the review petition, the following direction was issued by the learned single judge: take out whole of para 27. Interestingly, in the present writ appeal, initially, a judgment was delivered on 13th December 2012 by the division bench, allowing the writ appeal and setting aside the impugned order dated 16 September 2011, passed by the learned single judge in review petition number 25 2009. However, that order was assailed before the Supreme Court of India by the respondent in SLP Civil number 9325 of 2013, Full stop. By an order dated 8 March 2003, the Supreme Court of India passed the following order. Reproduced from page, it's there in the end. No, you see. Yeah. Pursuant to the above order, review petition 81 of 2013 was filed in this court, which came to be allowed by a judgment dated 7th December 2022. On the ground that the earlier judgment of the division bench had been passed against a single court's dead person, unquote. Full stop. As a result, the present writ appeal revived before this bench. Paragraph. On 19 December 2022, the following order was passed by this bench. Paragraph. As a result of the above order, the lacuna pointed out by the aforementioned order stands rectified, with the substitution having taken place. Paragraph. This court has heard the submissions of Mr. Ramakant Manti, learned senior counsel appearing for the appellants, and Mr. C. A. Rao, learned senior counsel appearing for respondents. Paragraph. What the impugned order of the learned single judge has done is to remand the matter to the Tahsildar for a fresh disposal. Sorry, revenue officer cum Tahsildar for a fresh disposal of the application under section 36 capital A of the Orissa Land Reforms Act. That is OLR case number 42 of 1976. So, considering that the case has been litigated for well over 4 decades, the court considers it appropriate to make the proceedings time-bound. The following directions are accordingly issued. OLR case number 42 of 1976 will be listed before the revenue officer cum Tahsildar. Which area is this, sir? Kalahandi. Nuapada. Sorry, Nuapada. On. There's no vacation and all there, or there is vacation?
No.
Vacation is there. Summer.
No, summer vacation. Summer vacation, they don't have summer vacation.
That's what I thought. 1st June, we can have it?
Yes. Since both parties are here, your lordship may direct us to appear on a particular date.
1st June 2023, on which date both parties will appear before the Tahsildar. By that, on that date, any further documents, affidavits that the parties wish to file should be filed before the Tahsildar. Stop. It is made clear that no further time will be granted to this purpose. 2, the Tahsildar will, after hearing both parties on dates, hearing both within a period of 2 months thereafter, pass a reasoned order, not later than 4th September 2023, and make the order available to the parties within a week thereafter. So the court clarifies that it has not expressed any view on merits. Stop. For that matter, any view expressed by the learned single judge on merits in the impugned order will also not be taken to be binding on the Tahsildar. It will be open to the parties to urge all the pleas available to them in accordance with law before the Tahsildar. Stop. No further directions are called for. The writ appeal is disposed of.
Obliged.
Lordship granted
2 months.
2 months time.
Item 78.
You say till the 1 minute, sir, till the above exercise is complete, the status quo as of today shall be maintained. All right.
Your Lordship, in matter 78, the matter is infructuous.
All right. Dispose of as infructuous.
Item 79.
29 minutes, may it please your Lordship. Your Lordship sees the order
The
dated.
status quo we've said.
79.
Item 79, my lords, if your lordship sees the last order, my lords, 9/2/2023, by detailed judgment, my lords was pleased to allow my writ appeal and the order of the honorable single judge was set aside. And your lordship had further directed the school and mass education department to file a compliance affidavit, compliance report.
What happened there? Disengage and engage.
I'll take instruction, your lordship, call this matter on Monday.
At the request of counsel for the school and mass education department to list on 28th March. All right. No, we'll have it on 21st March. 21st March.
My lords, can it be on 22nd, my lords, 21st?
All right, 22nd March.
22nd.
Correct. 22nd March.
Grateful.
Right.
Item number 80.
Last because when I was there, opposite party, northern matter in adjourn. I had filed a date set already. And I'm giving a copy of it. And date set is given to him.
One thing, my lord, I have to take certain instruction. Can it be next week, my lord?
All right. Counsel for the respondent seek some time for instructions. 11th April.
Item number 81.
81, my lord. On behalf of Mr. Why the senior counsel, my lord, next week, my lord, he has some personal difficulty.
Counsel for the respondent is stated to be in some personal difficulty. List on. There's an interim order.
Interim order is against me, my lord.
I know. Yes. Interim order. Continue. List on. 19th April.
19th April.
Item 82.
82, my lord, your lordship already issued notice, but there is a noting that notice.
Undelivered report, door locked.
My lord.
You served in counsel, sir. Who appeared for the notice issued to the sole respondent has been returned to the remarks. Single quotes, door locked. You see, counsel for the appellant is permitted to serve copy of the writ appeal on the counsel who appeared for the sole respondent before the learned single judge. Returnable on the next date. List on 16th May.
Item number 83.
Item 83, I am for the sole respondent. And lordship, other three matters identical to this case that has not been listed today. That is WA number 8.
All first day, sir.
No. Your lordship is already issued notice and the order of the honorable single judge has been stayed. Already issued notice, your lordship.
Okay. Your counter was already filed. What is this? The regulation
of DLR.
DLR. When is it coming up?
24th April.
21st April. All right.
24th.
24th. 24th April. All right.
Other three matters, my lords, may I provide the number?
Yes. Taken on board. Also listed with this 823 on 24th April. Interim order to continue.
Item 84.
Item 84 is a rehabilitation matter.
30th August.
Item 85.
My learned friend has appeared. It's a first day disposal. Can I give that order, my lord, in rehabilitation?
85.
First day disposal. Your lordship can remand it to
85 मतलब similar batch of cases are posted on
No, 1 minute,
27.
84.
84.
First day disposal.
Yes,
Let it
ma'am.
go back to the single judge.
As your lordship. This is also that rehabilitation matter, your lordship.
Send back. So dates we can just change.
Rehabilitation.
Item number 85.
The dates, we said 26th June, you file a counter.
Yes.
We listed on 3rd July. 86.
84 disposed of.
84, 85.
85 is rehabilitation, that departmental proceeding. Also this is-
85, 86 to rehabilitation.
85 time कोई departmental proceeding. This is also first day he has appeared.
If you want, you can send it back.
My lord, similar batch of matter posted on 27 March. My lord.
I know. One day, everything goes back on the same day before the single judge. That will be a problem, sir. If you're agreeable, you'll send it back.
8 news.
First day hearing.
This is also that departmental proceeding. That I have given that copy.
Same order will pass.
Will pass over. Can pass. On behalf of Mr. Das, will pass over.
Yes, let it come on 27th March.
He may agree, sir. Mr. Das may agree. Well, it pass over once.
My lord.
All right.
Item 86.
86 rehabilitation, same day.
Here also somebody is appearing.
You
are appearing. All right. 85, 86. Pass over.
Item 87.
87, my lord, my place. Let it come 1 week after, my lord. I have to take some instruction, lord.
You're for the appellant?
Yes, lord.
Counsel, the appellant needs time for instructions. What was the last order in this?
Yeah.
11th April. 11th April.
My lord. 11, my lord. 11th April. My lord.
Item 88.
My lord, 88 respond number 1 has filed a counter. I shall file a rejoinder.
Writ appeal, sir. What counter rejoinder?
Right.
Yes, sir, here stated.
Here, my lord, I am appearing for the respondent number 2, my lord. I have to file counter, my lord. Because
What's counter rejoinder? Writ appeal, sir. Appeal, there's no need for counter rejoinder.
My lord, appellant is a cooperative society. The respond number 1, husband was secretary in charge of a Pona Service Cooperative Society. That is the respond number 2. He has misappropriated more than 6 crores, my lord. He has also a locker in our bank. The appellant bank is a financing bank of the Pona Service Cooperative Society, respond number 2. My lord, the honorable single judge.
We passed a detailed interim order, sir.
Yes, yes. My lord, dispute case pending before the registered cooperative society, claiming against the respond number 1 more than 6 crores, my lord. Same is pending, my lord. That dispute shall be disposed of, my lord. This is a public money, my lord.
You have filed a reply.
Yes,
my lord. Who has filed the reply? Respond 1.
Yes.
I'm respondent 1. I filed the counter, my lord.
But even the opposite party number 2 is also filed.
My lord, I have to file, my lord, because last occasion there.
Oh, that only your counter before the single judge has been enclosed.
Yes. And let a copy of the counter and rejoinder which has been filed, that may be solved to me.
All right. Copies of the counter affidavit of respondent number 1 and rejoinder that too. You filed a rejoinder.
Yes, I shall file. No, I have not filed. I shall file.
Right at the beginning, you say respondent number 1 has filed a counter affidavit pursuant to the order passed with this court on
15/12.
18/12/2022.
15/12, sorry. 15/12/2022.
15/12/2022. No. 12/10/2022, sir.
I have received the 15/12.
Or 15/12.
Yes.
That order is not scanned. 15/12 order is not scanned. Just open the file, see the 15/12 order. Counsel for the appellant states that he'll file a rejoinder before the next date. Copies of both the counter affidavit of respondent number 1.
I have already
and
supplied
rejoinder that too.
I have already supplied copy.
No. Be served on counsel for respondent number 2. This is wrong. This is 5 plus 22. It's 23. Interim order to continue.
Matter short date may be fixed matter.
3rd May.
No, please.
Matter
3rd May.
Uh,
Item 89.
Pardon me, Lord, 87 interim order is there. Interim order to.
Interim order.
Item number 89.
89, but this is also rehabilitation assistance scheme.
30th August. You're there.
Copy may be right.
This is again first day, sir.
First day.
Let it go back. First day disposal. Same order, same. All those corrections. Rehabilitation assistance. It will come on 3rd July, sir. For the single judge, yes.
Item number 90.
90, I am for the sole respondent matters. This is also already received notice and the order has been stayed.
First day.
No.
Let it go back, sir.
First day. First day disposal.
First day. So let it go back. Same order. 90 also. Allowed. Same order. The entire thing will go back. Right.
All 3 cases.
Yes.
What has happened in first case, he has appeared. In 2 other cases, no one has appeared.
He is appearing.
No.
Are you appearing?
I am appearing in WA number 1264 of 2020.
In 93 matters are there.
So 1264 is allowed. The other 2, you say, when is that date? 30th August.
Well,
other 2, you say 30th August. All right.
Supplementary list, passport matter, item number 1.
None appears to dismiss. No. So you say on the first call, a passover is sought on behalf of counsel for the petitioner. On the second call, none appears, dismiss or non-prosecution.
Item number 6.
Names of alleged violators. What am
Lordship, in fact, Lordship, I have prepared. In fact, Lordship, I have collected in details, Lordship. But Lordship, can you see the peculiarity? Another
copy may be sought.
Yes. Subject to permission of the court, because I have disclosed the name. I don't want to disclose the names in public. Sand mafias, because
all right.
Page 2, Lordship, I have given Annexure 7 series, all the notifications.
Affidavit dated. All right.
May I be permitted to take an affidavit, because he is saying that unless the honorable court permits, I will give.
Because Lordship, kindly see, I have disclosed all the names of the sand mafias, Lordship. They are highly dangerous, and Lordship, kindly see. If it will be made public, then Lordship, it is. I have taken that ground also, Lordship. I have connected all the documents I attached.
All right.
Subject to Lordship's permission, I can get, but I have taken one ground, Lordship, because there is a threat.
If there is any threat you receive, you let approach the police.
Lordship, that observation, Lordship.
All right. I'm sorry. An affidavit has been tendered in the court today, in which, in para 5, 9 names of alleged violators has been set out. So the lie appearing for the petitioner apprehends that the petitioner, if the above names are made public at this stage, the petitioner may face threats. Full stop. You say notice, Mr. Mohanty accepts notice on behalf of The opposite parties. One to 13, 15 and 16. Notice we issued to the opposite party number 14 by Dasri.
Yes.
A direction is issued that if the petitioner apprehends any threats, receives any threats, it will be open to him to approach the SHO, the concerned PS of his area.
IIC.
IIC of his area, and on assessment of the threat, requisite police protection will be provided to the petitioner. Paragraph, the court at this stage is not impleading the persons named by the petitioner, as it would first like the state government to make its inquiries and inform the court on affidavit what the current position is.
Collector will.
The affidavit of the state government be filed positively by 26th by 1st May.
Lordship may say collector Cuttack will file.
By the collector Cuttack. Okay, by the collector Cuttack by 1st May 2023. List on 10th May.
Lordship. If Lordship permit me, may I point out another what they are doing, Lordship? I only demonstrate only 3 pages, Lordship. Lordship, kindly see what they are doing, Lordship. Can by getting these documents, I have asked Lordship state I have come to page 23 for a moment, Lordship. Page 23. Just I will demonstrate only 3 pages, Lordship. Page 23. Lordship, here Miller, Lordship, this is the advertisement. Page 23, Lordship. Lordship, kindly see the last column, the amount they have given, they have quoting, giving the target, Lordship. This is the quantity you have to extract. Accordingly, the advertise, they are conducting advertisement, Lordship. Then, Lordship, kindly come to page 34. Just only page 34, Lordship. Lordship, kindly see the amount. So far, Naranpuri, Lordship, 56,000, Lordship. But Lordship, kindly see, just I am highlight, Lordship, just first paragraph 1, 2, 3, 4, 5, 6, 7 line. Here the target is 56,000 cubic meter, but by of agreement they are doing Lordship 9,600. Lordship, kindly, then Lordship, kindly come to page 11. In every page 11, Lordship, here Lordship, kindly see there is 2 targets, Lordship. One is Lordship 30,044. And second is 1,40,112, Lordship. Then Lordship, kindly come to page 136, Lordship, for a moment. Page 136.
$20,000.
Lordship, this is 2,000. They have reduced. This
no, 20,000. 20,000.
So 20,000, Lordship. In 20,000. Then Lordship, kindly come to next page. That is 191.
No. What they do, they further outsource it, is it?
No, Lordship. What that they are putting, giving a very high amount, Lordship, so that no bidders will participate. And this is subsequent what they are doing by executive agreement, they are reducing the amount so that they'll deposit less, Lordship. And Lordship, in this amount
so
can be
to capture the
Lordship. This practice is rampant.
Lord, during the course of inquiry, the collector may issue notice to the violators.
Yeah. The collector will, in the process of conducting an inquiry, issue notice to the alleged violators, and after giving them a hearing, take appropriate action if he finds that the violations stand established.
Lordship. Grateful, Lordship.
Past on matter, item number 85.
He's agreed. He's agreed.
Agreeable. All right. Same order.
85 and 86.
Passover 1 million. Passover item 1. My lord, in this case, I may be permitted to withdraw the writ petition, my lord, with liberty to file a better application.
All right. This post is withdrawn with liberty to file a better plea. All right.
Support order.